Medical assistance in dying has been legal in Canada since 2016, and the legislation has recently been amended. Have you ever wondered who is eligible and what the process entails? Today's presentation will provide a brief history of how MAID came into law, outline eligibility criteria as well as the application and assessment process, and describe what is next for existing legislation. Our presenters today are Nora Ohanjanians. Nora is a retired teacher, an interpreter, a blogger, and of course, a volunteer with Dying with Dignity Canada. Nora thinks our society needs to more actively engage with end-of-life matters and wishes to contribute to Dying with Dignity Canada's efforts to raise awareness about advanced care planning and MAID. Marianne Security is a retired healthcare consultant and chair of the Greater Toronto Area chapter of Dying with Dignity Canada. She is a subject matter expert and will come in during the Q&A portion of the meeting. Marianne is currently building the chapter with passionate, like-minded individuals whose goal is to inform and educate the public and other stakeholders in our community on MAID and MAID-related topics, as well as advocating for improved access to medical assistance in dying. She's also a volunteer independent witness for those seeking MAID and a researcher for the National Office of Dying with Dignity. So without further ado, I will turn over the meeting to our presenter, Nora. Good morning, Nora.
Good morning. I'm going to share my screen here. Here we go. Can everybody see it?
Yes.
Excellent. Okay. We're living in strange times. Death and dying are being reported in unprecedented numbers on the evening news, on the social media. It seems like people are dying everywhere around the globe, in our country, sometimes in our neighborhoods. So death and dying are on our minds a lot these days. My name is Nora Ohanjanians, and let me tell you why I'm here today talking to you about assistance in dying. I have watched 3 people whom I loved very dearly die long, protracted suffering deaths. The last one of them was my mother. Mom had Alzheimer's for the last 17 years of her life. Once she started losing her faculties, she did not want to live anymore. She asked me repeatedly to help her die, but I couldn't. It was very heartbreaking for me. MAID wasn't legal then, and even if it was, she wouldn't have qualified. When my turn comes, if that's the kind of death I'm going to face, I'd like to have a choice. If living looks scarier than dying, then I would like assistance to help my suffering, to end my suffering. Let me share with you the objectives of this talk. They're pretty simple, really. If you have the knowledge of the options available to you, you can make informed choices in your planning and decision-making. And ultimately, you can have more control over the end of your life situation. So what are we going to cover? We're going to talk about who we are at Dying with Dignity Canada, what is medical assistance in dying, how it became legal in Canada, the eligibility process, what's new. Some of you will have read about changes to the legislation that happened lately, and what's on the horizon, anticipated changes to the legislation. And at the end, my associate, Marianne Security, who's a subject matter expert, will answer your questions. So who are we at Dying with Dignity Canada? We are a human rights charity. We have over 2,500 members. We started in Ontario, and now we've grown to be a national organization. In 2020, we celebrated the 40th anniversary of Dying with Dignity Canada, advocating for the right to choose how and when we die. What do? We defend human rights by advocating for assisted dying rules that respect the Canadian Constitution and the Canadian Charter of Rights and Freedoms. We get no government funding. We are funded by average Canadians who believe there's a better way to die. The recent Ipsos Reid poll showed that 85% of Canadians support MAID for those individuals that meet the eligibility criteria. Our focus is fourfold. In terms of eligibility, we ensure that assisted dying legislation complies with the Canadian Constitution and the Charter of Rights and Freedoms. In terms of access, we work to ensure that Canadians can access MAID in compliance with Canadian Constitution and the Charter of Rights and Freedoms. We support people, their families, caregivers, and healthcare providers as they explore end-of-life options, including MAID. And we lead education initiatives, such as this one, for healthcare professionals and the public on patient rights, end-of-life options, including MAID and advanced care planning. How do we do this? We support and intervene in court challenges related to Bill C-14, which is the federal legislation that allows for MAID. We work to ensure that clinicians who object to MAID are obliged to offer effective referrals for those seeking MAID. And we provide information, emotional and personal support resources to those interested in MAID. Let's define MAID. I'll give you a couple of minutes to read the definitions. So MAID, medical assistance in dying, is either the administration of a substance by a medical practitioner that causes death, or prescription and providing a substance to a person for self-administration that causes death. In both cases, it's at the person's request, and I will repeat it a few times during this presentation. Nobody else can request MAID for you. Let's go back and see how MAID became legal in Canada. 3 women fought very bravely for assistance to for access to assistance in medical dying. The top picture is of Sue Rodriguez. In 1993, she was 42 years old, suffering from ALS. She wanted medical assistance in dying, and she took her case all the way to the Supreme Court of Canada and asked them the question, if I cannot consent to my own death, whose body is this? Who owns my life? The Supreme Court of Canada upheld the criminal code provision in a 5-4 decision. In other words, it remained a crime to assist someone in dying. In 1994, with the assistance of an anonymous doctor, Sue Rodriguez took her own life by drinking a liquid mixture of morphine and secobarbital. Fast forward 20 years. We meet 2 other women who were important in the fight to make MAID legal in Canada. Gloria Taylor, who is the one on the lower left, was suffering from ALS, and Kay Carter on the right was suffering from degenerative spinal stenosis. They joined forces to change history in Canada. Unfortunately, neither women lived to see the fruit of their work. They both fought vigorously in court on behalf of Canadians for the right to die. But Kay Carter got her assisted death in Switzerland in 2010 the only country that allows non-residents to access MAID. And Gloria Taylor died of a severe infection in 2012. The legalization of MAID in Canada. On February 6, 2015, the Supreme Court of Canada's decision in Carter versus Canada case was released. The Supreme Court of Canada determined unanimously that the prohibition on assisted dying infringes on individuals' Section 7 rights to life, liberty, and security of the person. So before, it was a 5-4 decision against MAID, and in 2015, it was unanimous for MAID. The resulting MAID legislation, called Bill C-14, was put into law in June of 2016, which is not very long ago. Since then, over 13,000 Canadians have accessed an assisted death to release them from their pain and suffering. Let's look at MAID and the eligibility criteria. The decision to seek MAID is not undertaken lightly, and certain criteria must be met. First of all, you have to be eligible for publicly funded healthcare services called OHIP in Ontario. You have to be of legal age and mentally competent, which means having the capability to make your own healthcare decisions. You have to have a grievous and irremediable medical condition, and we'll talk a little bit more about this soon. Your request must be voluntary. People who are assessing you must make sure that nobody is coercing you or pressuring you to seek MAID. And the person must be aware of all the medical options available to them to relieve their suffering, so they are informed in their decision to pursue MAID and ultimately give final consent. Now let's go back to this term grievous and irremediable. What does it exactly mean? It means that you have to have a serious illness, disease, or disability that cannot be cured. It means that you have to be in a state that your illness has to be in a state of decline that cannot be reversed. And you have to be experiencing unbearable physical, mental, or psychological pain and suffering that cannot be relieved under the conditions that are acceptable to you. And the fourth criterion is your natural death must be reasonably foreseeable. And that is in red because it requires most discussion and more discussion, and was the focus of a recent legislation and articles you might have read about it. Because changes occurred in the recent passing of Bill C-7. So let's go back a little and introduce you to two people who challenged this reasonably foreseeable death requirement. Jean Trouchon, who suffered from cerebral palsy, and Nicole Gladue, who suffered from post-polio syndrome, joined forces and in 2019 took their case to the Supreme Court of Quebec to challenge Bill C-14 regarding the eligibility criterion for reasonably foreseeable death in order to access MAID. The Quebec court ruled that the need for a reasonably foreseeable death in order to be eligible for MAID was unconstitutional. The federal government agreed, and as a result drafted Bill C-7, which was a further amendment to the Canadian Criminal Code and broadened the eligibility criteria for MAID. In March 2021, just a few months ago, Bill C7 received royal assent and became law. It now allows for people whose death is not reasonably foreseeable to seek approval for MAID. However, this leaves us now with a two-track system: those whose death is reasonably foreseeable and those whose death is not reasonably foreseeable. Now, you might ask, what were the issues with this requirement, with this criterion? First of all, it was a very ambiguous legal term. It became difficult for clinicians to interpret it and apply it to those who were seeking MAID. Secondly, it excluded chronically ill Canadians with enduring pain and intolerable suffering. And it created inconsistencies around access to MAID for depending on which medical professional assessed you and how they interpreted the term and applied it to you for eligibility. So this is one of the things that Bill C7 changed. It gave a pathway to those who have enduring suffering and want access to MAID. So I mentioned that it created two tracks, and the next table will hopefully shed some light on the differences between the two tracks. As of March 17, 2021, safeguards are based on whether or not one's natural death is reasonably foreseeable. So if the death of the person is reasonably foreseeable, in terms of the written request, the person must only have been told that their condition is irremediable by their healthcare provider and acknowledge that they have been informed of the means available to them to relieve suffering, including palliative care. If the death is not reasonably foreseeable, they must be informed of available and appropriate means to relieve their suffering, including counseling services, mental health and disability support services, community services, and palliative care, and must be offered consultations with professionals who provide those services. And they and their practitioners have to all agree that all alternative means to relieve their sufferings have been considered. So these are some very important safeguards. In terms of medical assessments, any two medical professionals can assess a person whose death is reasonably foreseeable. No expertise is required from the medical professionals. Whereas if the death is not reasonably foreseeable, at least one of the two assessors must have expertise in the medical condition that's causing the extreme pain and suffering. For example, in Nicole Gladou's case, it must have been someone with expertise in post-polio syndrome. If none of the two medical assessors has expertise in the condition, then a third assessment has to take place by a medical professional who is an expert in the medical condition. In terms of the waiting period, if death is reasonably foreseeable, there is no waiting period after the two assessments have been made, and two independent medical professionals have agreed that all the criteria have been met. But if the death of the person is not reasonably foreseeable, there is a 90 days waiting period from the date of the first assessment. In terms of the final consent, it may be waived for people whose death is reasonably foreseeable. But if death is not reasonably foreseeable, the final consent must be given. So there are some very strict safeguards for people in both cases, but especially when death is not reasonably foreseeable. Now let's see how the MAID process rolls out in Canada. First is initial inquiry. When a person asks their doctor or healthcare provider about their end-of-life options, the doctor has to include MAID, has to include treatment, palliative care, and MAID in their answer. The response to that request must include medical assistance in dying. So what happens if your doctor doesn't support medical assistance in dying? In Ontario, they are obligated to refer you to make an effective referral, that's in quotes, from the legislation, to an available, accessible physician or agency that is willing to facilitate a request for assisted dying. The next step is the written request. If a person wants to pursue MAID, then they have to fill out a written request. In Ontario, the main one is called Clinician 8A form. This written request establishes a number of things. First, that you have met the eligibility criteria. We talked about those. Second, that you are capable of making the request, that you have a clear understanding of your medical condition and the options available to you to treat your pain and suffering. The signing of your written request must be witnessed by an independent witness who has to meet certain eligibility criteria. And if the person requesting MAID cannot sign and date their form, then an authorized third person may do so at their request. And that authorized third person also has to meet the same eligibility criteria that the independent witness has to meet. Now, worth mentioning that making a written request for MAID does not mean you have to go through with it. This is all about making an informed choice. The next step is the assessments. A doctor or a nurse practitioner meets the person to determine whether their condition meets the grievous and irremediable criterion, and if they are competent to make their decision. It may include more than one meeting, more than one clinician, and a full review of the medical records. Then a second independent assessor, a doctor or a nurse practitioner, has to do the same. If two assessors independently agree that all criteria have been met, a MAID procedure can then be planned for people whose death is reasonably foreseeable. If the death is not reasonably foreseeable, the assessment, there has to be a 90-day reflection period starting from the day of the first assessment for that person. As an aside, if the person requesting MAID is not happy with the two assessments that they received, they can request a third assessment or a fourth assessment. Once the procedure is scheduled, the MAID provider issues a prescription and picks up the drugs that are needed on the day MAID is to be provided or self-administered. Prior to administering the drugs, the person receiving MAID is asked to give a final consent for the procedure to the provider. This consent can be verbal or physical if the person can't talk. or the person can decline the procedure. They don't have to go through with it. If consent is given or it has been waived, more on that shortly, drugs are administered for a quiet and peaceful death that is not painful at all. It takes about 10 minutes. Death is pronounced and certificate of death is issued. If anyone is interested in personal stories of experiences about MAID, they can go to Dying with Dignity Canada website and read the blogs there. There are some very heartfelt stories there. Now let me introduce you to another woman who caused legislative change. This is Audrey Parker. In 2008, Audrey Parker, a Halifax woman, was suffering from stage 4 breast cancer that had metastasized to her brain. She chose MAID, but she wanted to have one last Christmas with her family. However, she was afraid that if she waited until Christmas, she wouldn't be mentally competent to give her final consent. So she chose to die earlier. She had MAID in November instead of after Christmas. Audrey realized that there was a big flaw in the legislation, as did others. Bill C7 now contains Audrey's amendment in the form of the waiver of final consent. If that was the case when Audrey was alive, she would have been able to sign a waiver of final consent and spend one last Christmas with her family. Now let's look at what's up ahead. There's going to be a comprehensive review of the MAID legislation over the next 2 years, and it's going to be done by a joint committee of the Parliament and the Senate. This parliamentary committee is going to review some important issues and come up with some important safeguards. The main issues that this committee is going to review are mental illness, advance requests, mature minors, and protection of people with disabilities. Mental illness has as the sole underlying medical condition to seek MAID has been excluded from the legislation for the next 2 years. During the next 2 years, the Government of Canada will hear from experts and develop safeguards and protocols for people who seek access to MAID with mental illness as their sole medical condition. The committee will also consider advanced requests. So anyone with the onset of dementia will hopefully be able to have an advance request, and they will be able to determine that, let's say, come the time that I don't recognize anyone, or that I can't feed myself or take care of myself, I want medical assistance in dying. Eligibility of mature minors is going to be considered as well. And a mature minor is defined by law as a person under the age of 18 who has the intelligence, the maturity, and capacity to understand the nature, purpose, and consequences of such a decision. And the committee is going to consider the protection of Canadians who live with disabilities. The committee is required to submit its report to the Parliament no later than April of 2022. Let me summarize the key points of this presentation. MAID is legal in Canada, and it's your right as a Canadian. It's important to know all end-of-life options in making your end-of-life choices and thereby having control over your end-of-life scenario. No one else but you can request MAID or give consent to MAID procedure on your behalf. A request for MAID can be withdrawn at any time and never acted upon. This is a nice quote. Every story has a beginning, a middle, and an end. The more we participate in writing the end of our own story, the more satisfied we are with the arc of our life. MAID allows for planning. Being in the place you want and having the people and things you want to be surrounded by at the end of your life is very reassuring and comforting, both for the person and their family and friends. MAID has been described by those present and providers as being very comforting and peaceful. At Dying with Dignity Canada, we believe everyone has a right to choose a good death. Thank you for listening. Now, Mary Ann Secuti will answer your questions.
Okay, thank you very much, Nora. Thank you so much for providing such an informative and orderly presentation. It was very easy to understand and had a lot of information that was very good. I'm someone who's been exposed to Dying with Dignity for some time. In fact, since we had a presentation from Dying with Dignity about 5 years ago, before the legislation was even signed, I believe, we had a symposium at HAT with 3 different speakers from Dying with Dignity, and it was an eye-opening experience for me, and that caused me to get involved with the organization. But even as someone who's been involved with Dying with Dignity for some time, there was still a lot of information here that was new to me. And so I thank you very much for presenting your topic today. And again, maybe we could come off mute for a moment and just give Nora a round of applause for her presentation today.
Thank you.
Thank you. Thank you.
Thank you very much, Nora.
My pleasure.